Welcome to the Pentagon Papers and Watergate panel. Today we have an illustrious set of panelists who are going to talk about the Pentagon Papers, Daniel Ellsberg's disclosure, the publication, and how it intersects with Watergate and subsequent investigations. Too often we think about and we talk about the Pentagon Papers and Watergate as distinct and separate. Hopefully, this panel will provide a fresh perspective on the Pentagon Papers and its publication and Watergate and the subsequent investigations and demise of the Nixon administration, and shed a little bit of light and provide a bit of backstory so we can kind of examine a little bit of the intersection between Ellsberg and the Pentagon Papers and Watergate. My name is Julia Rose Kraut, and I am honored to be the moderator for this panel. I am a lawyer and historian who writes about immigration and the First Amendment. I am the author of Threat of Dissent, A History of Ideological Exclusion and Deportation in the United States. I am also the author of an essay on Daniel Ellsberg's trial and his lawyer, Leonard Boudin, as part of a great new book called Whistleblowing Nation, The History of National Security Disclosures and the Cult of State Secrecy, edited by Hannah Gurman and Caden Mystery. I will now briefly introduce our panelists. Their bios are on the conference website as well as online. And we have today Hedrick Smith, who is a Pulitzer Prize winning former New York Times reporter and Emmy Award winning producer. While at the Times he covered Saigon, Moscow, and Cairo, headed the Washington Bureau, and was a principal reporter for the Pentagon Papers. He has also authored 5 best-selling books, including Who Stole the American Dream, and he now edits the website reclaimtheamericandream.org. James Goodale is a First Amendment expert and the former vice chairman and general counsel of the New York Times. And he led the fight to defend the Times in the Pentagon Papers case. He is the author of Fighting for the Press, the inside story of the Pentagon Papers and Other Battles, twice named as Best Nonfiction Book of the Year. Morton Halperin is a senior advisor to the Open Society Foundations. He served in the Obama, Clinton, Johnson, Kennedy, and Nixon administrations. He was also the director of the task force that produced the Pentagon Papers and was on Nixon's enemies list. He has been affiliated with think tanks, including the Brookings Institution, and is the author of books and articles, including Bureaucratic Politics and Foreign Policy and Strategy and Arms Control. Elizabeth Holtzman served 4 terms in the House of Representatives and was the first woman elected district attorney in New York City and New York City Comptroller. In Congress, she served on the House Judiciary Committee during the impeachment proceedings against Richard Nixon. She also drafted the unsuccessful impeachment resolution for Nixon's secret bombing of Cambodia, and she was a plaintiff in the landmark lawsuit to stop military action in Cambodia. She currently practices law in New York City. John Dean served as counsel to the President of the United States in the Nixon administration from July 1970 to April 1973. He provided crucial testimony before the Senate Watergate Committee, agreed to cooperate with Watergate prosecutors, and pleaded guilty to conspiracy to obstruct justice. He has written 3 books about the Nixon administration and Watergate, including The Nixon Defense, What He Knew and When He Knew It. He is a political legal commentator and contributor for CNN, and he is currently working on a book about Donald Trump's presidency. Let's welcome the panelists. with a lightning round. We're going to have 10 minutes talk very briefly about when they first learned of the Pentagon Papers or of its publication and their impression of the significance of the papers and its disclosure to the public. Let's start off with Morton Halperin.
Well, I first learned about the Pentagon Papers long before they existed, and of course, long before they were called the Pentagon Papers. I was working in the Defense Department. I was called to the office of my boss, John McNaughton, and there was one of McNamara's military assistants who explained to us that McNamara wanted us to prepare an encyclopedic history of the U.S. involvement in Southeast Asia with appropriate documentation, and said McNamara wanted us to figure out how to create the study and how to do it. And I set to work with my colleague Leslie Yale, who was the day-to-day manager of the study, to design the study, to recruit the authors to write the studies, and then to finally the project was finished in the beginning of the Nixon administration, and we distributed it to some government officials, having no idea it was going to become public, nor that it was going to be called the Pentagon Papers.
Right. Elizabeth Holtzman.
Well, I was in private life then, but I've been a long opponent of our involvement in the Vietnam War. The Pentagon Papers weren't really a surprise in the sense that, of course, the war was obviously a mistake, was a tragedy, and the Pentagon Papers has confirmed that. Of course, the importance of those papers is the fact that having government disclosure of what's going on inside the government is vital for our democracy and public understanding of what's happening. We see too much still today of effort to hide what presidents are doing. And we saw that clearly in the Trump administration. That's a big problem, and the Pentagon Papers and Ellsberg's role was vital in disclosing them, and we still have the issue of disclosure of government secrets with us today.
Hedrick Smith.
Well, for me as a reporter who had been working on the war in Vietnam for the New York Times and covering it in Washington, it was a bombshell. I was overwhelmed. I was stunned. I was shocked. I was impressed. Shocked because it's 7,000 pages of documents that Morton and his team had put together. It was drawers full of classified, top secret, eyes only communications between the president and the ambassador in Saigon, the chairman of the Joint Chiefs and the American commander in Vietnam. I mean, just unbelievable material. I was shocked because suddenly there we were. I'd never dealt with as a reporter a classified document. And here were 7,000 pages of them, and the most secret of all. It was stunning and impressive because it obviously showed that McNamara, the Secretary of Defense, had become personally so disillusioned with the war that he wanted a record, as Mort just said, how it happened. How did we get into it? And as Elizabeth Holtzman was saying, how do you justify this to the public? So I was curious, I was engaged, and I was, as a reporter, I had to then work with Neil Sheehan and later on a couple of other reporters to try to figure out how to write this thing up and put it into the paper. When the New York Times was done with it, you have to understand it is the size of Gone with the Wind as a book. When the New York Times total publication, it's a total book. So we had to produce that. We didn't have any idea when we first looked at the papers how many stories we would do. We had to figure all that stuff out. So, I mean, it was overwhelming. It was stunning. It was amazing. It was a bombshell.
Excellent. I think James Goodale.
Well, I first learned about the papers when they were rolled into my office in supermarket carts, about 8 carts. I didn't know what to do, so I plunged into the first volume, and immediately I read about the deceit, deception, and the lies with respect to the 1948 Geneva Convention. And I was just as angry as Rick Smith was. I couldn't believe the U.S. had lied. But the question was, what was I supposed to do with that information? I'd been in the intelligence reserves For 6 years, I was an intensive history major in college, and I knew the first thing you do is when you read something, as I read in the first volume, is look for the sources. I went right to the footnotes and started reading the footnotes, and the sources were, by and large, the New York Times, Stuart Lurie, all public information. So I said to myself, one, I'm just as mad as Hedrick Smith, and number two, I know damn well if all we're doing is republishing what the New York Times has published, these can be published some way, somehow.
All right. John Dean.
I come at this from two angles. First of all, what I knew contemporaneously in the White House, and secondly, having gone over the same ground through the Nixon tapes, documents, and what have you in the years that follow. So I first learned of it on the weekend of Nixon's daughter's wedding when they're published. What I learned subsequently on Monday with a call from the Oval Office from John Ehrlichman with the question is, could the Department of Justice bring a criminal action against the New York Times? And I said, well, I'll check on that. So I called over to the Office of Legal Counsel, Bill Rehnquist, who was then the Assistant Attorney General in charge, said, I'll have to get back to you also. They came back a couple days later, said, yes, they could be criminally charged. It is a matter of policy under the First Amendment in the Department of Justice not to bring criminal actions in such cases. But I learned much more in the days and weeks and years that came, that Nixon's first reaction to the papers was very mild. He said, this is good for us. This will really be a problem for the Democrats because they're the ones who've been deceiving. It's not reached Republicans. And so he felt very comfortable about it. It's not till Henry Kissinger comes back to town on Monday and tells the president, and in my estimation, presses the president's manhood button, that everything changes. As my friend Alex Butterfield, who really was the most frequent daily observer of the president's moods, said everything changed with Nixon after the leak of the Pentagon Papers and after his meeting with Henry. It really was a moment that affected the White House deeply. We all saw it and felt it in the weeks that came, but we can travel in that direction later.
And we will, as we get kind of deeper into this discussion. So excellent lightning round. We're going to go into a little bit of kind of painting a picture, creating a narrative between 1971 and 1974. And what we want to do is tease out a little bit of this connection between the Pentagon Papers and Ellsberg's disclosure and his trial and prosecution with the Watergate break-in and subsequent investigations and eventual resignation by Nixon. So to do that, let's begin with Hedrick Smith. So you're a reporter for the New York Times. If you can tell us a little bit about your reaction, which you began to tell us in this brief lightning round, what it was like to work with the team, looking at the papers and trying to write about its significance. So start us off, Hedrick Smith.
Well, for the team was Neil Sheehan and me for about 3 months, and a deputy foreign editor named Jerry Gold. First of all, just dealing with that much classified material, we had to decide what to do. We all knew we were at some risk. Listening to John Dean talk about their consideration in the White House about whether to do criminal prosecution, we were worried about whether or not the FBI was going to catch us with these classified documents before we were able to do anything. It was a huge job. The first question was, is there a national security problem in our publishing these papers? We had to take a look at it. The papers basically cut off, and Mort will correct me if I'm wrong on this, at the end of the Johnson administration in 1968. So Nixon was right. It didn't deal with the Nixon era. So if you're looking at any risk to American military personnel, to troops, to military actions, to anything going on in Vietnam at the time in 1971, there was nothing in the papers that dealt with that. So were we harming national security? That was the major question we had to answer. The answer was, after we looked through it, no, we would not be, except for one thing. There was a diplomatic annex. And in the diplomatic annex, there were papers that dealt with diplomatic initiatives through France, through Burma, through Australia, through various different other countries to try to get peace talks going in Vietnam by the Johnson administration in particular. And we had no idea whether or not any of those were continuing, whether or not any of those avenues were still open. So I said, I'd been the diplomatic correspondent for the New York Times, covering mostly the diplomacy. I said, we can't go into that. We have no idea whether or not if we publish something, we will damage national security. So we were very mindful of that. There were a lot of charges later on that the publication of the Pentagon Papers damaged national security. We believed we were perfectly safe journalistically. We were very conscientious about it. But then we started to plunge in. Sheehan and I had written separately and together a slew of stories from Vietnam, from the Pentagon, from the Capitol Hill, from the White House, whatever, about Vietnam. I found out later that my phone actually had been tapped by Kissinger and company, but I didn't know it at the time because of some of the stuff that I'd written on Vietnam. And even though, as Jim Goodale says, a lot of the stuff you'd seen in print, when we saw it in black and white, messages from Kennedy or from Roger Hilsman, the Assistant Secretary of State, essentially agreeing to go ahead with the coup in South Vietnam to overthrow the regime of No Dinh Diem. Well, we'd written about that, but we'd never written about it with any certainty, with the same way. We wrote at one point that Westmoreland had asked for 206,000 more troops. The administration had denied that. Turned out it was absolutely accurate. Time after time, shock after shock. And then, as Jim Goodale suggested, it went all the way back to the Eisenhower administration, the 1950s. It was simply, it was almost like being in a prize fight. You were pummeled one day after another with the lies the successive administrations had told to the American people. It was overwhelming. And I think as we worked into it, and it was great, Jim Greenfield, the foreign editor, Abe Rosenthal, who was a hawk on the war, the executive editor, they had no qualms, no question that this was information that the American public had a right to. As Neil said, we've paid for it. The American people have paid for this information with blood and treasure, with 58,000 lost lives and a whole lot of billions of dollars of spending. So the notion that this was a public service, the government knew this. McNamara had put it together. Morton and his team had put it together. The government knew about it. Why would it be kept from Congress? Why would it be kept from the media? Why would it be kept from the American people? So I think that was the basic thrust of our conclusion about whether we should publish and whether or not we were damaging national security. Then the problem became enormous. How are we going to deal with this? My recollection, Mort, is it was organized, the study was organized into 10 chapters. And Sheehan had the idea we would produce 2,000-word stories all summer long. I said, we'll never get that done. They'll come and shut us down before we ever get a chance to get it done. And by the way, we never were Sheehan and Smith. We lived for 3 months in the New York Hilton Hotel at 55th Street on 6th Avenue. We were registered as Gerald Gold. We called room service as Gerald Gold so that they would never find us by our names. But I said to Neil, the government's not going to wiretap us. We're reporters. We're doing our job. He said, Rick, you got to be secure. As I said, I didn't know it. 2 years earlier, they had wiretapped my home telephone in Washington, and I found out about it later. So we were conscious of that security. And then we gradually developed the strategy. I think it was Greenfield who led us this way, to basically take each of the chapters of the Pentagon Papers, dealing with the Eisenhower administration, dealing with the Kennedy administration, dealing with the Johnson administration, several chapters for each. And we broke it out and we began to write stories of what those chapters revealed about that period of the American engagement in the war in Vietnam. And then they assigned a team of editors and researchers to work with us to go through the documents, the footnotes that Jim Goodale was talking about before, so that when we published stories that were like 10,000 words long, there were maybe 50, 60, 70 selected top secret documents that went with each segment of the story, so that you could, if you wanted to, you could go from the story, which told you the basic narrative of a period of, say, the overthrow of Ngo Dinh Diem, or the initial commitment of American troops to Vietnam, or the bombing of North Vietnam, whatever it was, that was the subject of that section. And you had the documents that went along with it. It was a massive story. And then we got to the end of this, and the Times got worried that the FBI might find us. So it moved Neil Sheehan and me into the Times building. We stayed in the health clinic of the building because they figured the FBI would be less likely to raid the New York Times building than if they found us in the hotel in Midtown Manhattan. And then on the final day, and Jim Goodale can probably tell you more about this than I can, we worried that the publisher might change his mind and not go ahead with it. So Jim Greenfield, the foreign editor, took the publisher out to play golf on the Saturday that the presses were being put together, when actually rolling with the papers. If you want any more detail, I mean, it's just a massive story to put together, exciting, important, and I think it's had a heck of an impact on the media ever since then, but maybe we can talk about that on another round.
Well, thank you so much for providing that behind the scenes glimpse at this process of publishing the Pentagon Papers. June 1971 was an action-packed month. So you had the first installment of this Pentagon Papers series published on June 13th, which is followed by efforts from the Nixon administration to stop the publication, which leads to legal challenges in federal court. More newspapers like the Washington Post begin to publish the papers. And by the end of the month, you have the Supreme Court weighing in, rejecting the Nixon administration's argument to stop the papers. And then 2 days later, Daniel Ellsberg is indicted by a federal grand jury in Los Angeles for theft and unauthorized possession of documents related to the national defense under the Espionage Act of 1917. So, James Goodale, you served as general counsel to the New York Times. Can you tell us a bit about your role in the determination to publish the Pentagon Papers, and then a little bit about this legal fight that followed and ended up in the Supreme Court?
Well, the first thing that happened was that I was sidelined in the case, and I would go back in time, if we're looking at a timeline here, back to 1968, when Nixon threatened to sue the Times. For the 3 years from 68 to 71, I was totally prepared for something to happen, and I even had boned up in prior restraints. However, the law firm that represented the New York Times on the outside was not fully prepared, and when they were given the Pentagon Papers issue to decide, they came without notice to me, to the publisher in a meeting that took place on the executive floor, and advised them that they, the law firm, couldn't touch the Pentagon Papers or they would go to jail. And everyone in the room, and that included all the principal editors of the New York Times and me, would go to jail too. I was sitting down at the end of the table, so far below the salt you need to look for me with binoculars, and I peeped up that perhaps they had it all wrong. There was a First Amendment, and what was going to happen was we were going to get enjoined. After the date of publication, the Nixon administration moved to stop a publication and called my superior, Harding Bancroft, and said, if you don't stop publication, we're going to go in and stop it for you in court. And we're going to follow this up with a telegram. I thought actually that day, since I was fully prepared for the worst, that this was going to happen, but I got a little hungry and went home. And I was waiting for the phone to ring because I was sure something was going to happen. It never rang, and I had the feeling I was being frozen out. I volunteered my services, rushed back up to the New York Times as fast as I could get there. And as I came up the stairs and on the executive floor, I heard this screaming and shouting as though two people were going to shoot each other. And I opened the door, and there was the aforesaid Abe Rosenthal, who was now 100% behind the publication, always was, and Sidney Gruson, who was sitting in for Punch Sulzberger, who had decided to go to Europe. The two of them were fighting over the future of the Times in a way. And so I walked in and I said, "What is going on?" And they said, "Look at this." And they handed me the telegram about which I just made reference. And I looked at the telegram and it said, "Stop publication." I said to everyone there, by the way, I'm a generation younger than everyone else in the room. I said, "You don't stop just like this. You don't stop publication when someone sends you a telegram." And all of a sudden the room grew quiet. And then someone said, "Well, maybe we better call Ellsberger." So they called Ellsberger on the phone, and I got on the phone after being prompted and kicked and so forth, and said what I just said. He said, "All right, go ahead." Now the problem was to find someone to represent us in court, because even though we would go ahead and publish and disobey that telegram, surely we would be sued, as the telegram said. So I called Herb Brownell, who had been in on giving the advice at that meeting to which I referred earlier, former Attorney General of the United States, friend of John Mitchell, friend of Nixon. And I said, "I want to see you in court tomorrow." He said, "No, you are not going to see us in court." I said, "Well, why not?" He said, "I have a conflict of interest. We can't represent you." Well, that time it was 11 o'clock at night. We're probably going to be in doing court in 12 hours from that point in time. So what to do? Well, going back to having been prepared, I had put a team together of Alex Bickle and Floyd Abrams and myself to take on the Nixon administration with respect to a subpoena they had issued to a black reporter, Earl Caldwell. That case was going to the Supreme Court. The three of us had worked together for almost a year, and we knew each other well. And I told Harding Bancroft, who was my superior, if I could find them, I think they will do it. I got on the phone, the time is ticking away, and I can't find them. So I said to myself, well, I'll do it. I have to do it myself. Only one trouble doing it myself. The only time I've been in court was for an uncontested divorce case. But I was quite confident that everyone would feel sorry for me if I was there trying to defend the Times against the U.S. government. So off I went, stopped by the newsroom to tell them of the news, and I said I couldn't find Bickle, and I went to bed. I think I'd be in court. The phone rang, the newsroom called, "We found him." So I got on the phone. I got Bickle to agree. I got Abrams to agree. And we litigated the case and actually lost it in the Court of Appeals in New York City. But as you pointed out a few minutes ago, we ended up in the Supreme Court just a few days later, reasonably well prepared, but not fully prepared. Argued the case, and a few days later, much to our relief, we won.
And tell us a little bit about that win and the argument. So that argument is about prior restraint, and the argument that the government puts forth fails. Can you tell us a little bit about the Supreme Court's decision?
I certainly will.
Okay.
The advice that was sought from Rehnquist, if we go back to what John Dean said, was what was the criminal liability for the New York Times to publish. And as I've just described the case, it didn't turn on that at all. It was an order not to print, which in legal terms is known as a prior restraint. It was the first time in the history of the federal courts any such order had ever been granted. First time in the history of the United States any such case, therefore, had gone to the Supreme Court. And it was a dramatic argument. And it's fair to say all of the attention of the United States was on this argument before the Supreme Court. Alex Bickel stood up against Supreme Court pressure, answered a very dicey question from Potter Stewart, who was the justice we were counting on to swing the balance, and we won 6-3. The case is very important for all of us, for the First Amendment, for constitutional law, because what the Supreme Court decided was that it is virtually impossible under the First Amendment for the government to go in and stop the press from printing. So therefore, as of today, and I would venture probably forever, the case stands as a case for the ages on that particular point.
And Hedrick Smith, what was your response to the Supreme Court decision as a journalist, as someone who...
I have to tell you, it was phenomenal. It was phenomenal. We knew, Jim knew the law better than we did, but I can tell you, Neil and I were worried that we were going to be arrested for taking stolen goods, for dealing with classified documents, for supposedly aiding the enemy, whatever it was. And we were prepared to go to jail for that. And then to find out that, number one, as Jim just laid out, that there really was no way for the government to bring a criminal case against us at that point. And then to have the argument, basically, can you have censorship? And we all believed you couldn't, but we didn't know what the court was going to say. It was an explosion of relief. It was a great sense that the system had worked, that the First Amendment had worked, that the press was free to probe. After all, this was politically embarrassing information for powerful people. There were all kinds of lies and mistakes that were being covered up. This was opening it up, and then we're living with that today. I mean, if you look at all the stuff that went on during the Trump administration with the 2 impeachment attempts and all the various pressures that were put on various agencies, the effort to interfere with the counting of the election votes, the president's telephone calls to the Secretary of State in Georgia on the vote counts and so on. All that liberation of the press to do that was enhanced and enabled by the Pentagon Papers and the court decision there. So the impact for journalists was phenomenal and long-lasting and enduring. And we knew it right away. The other thing that Jim has left out, and it's understandable, is Ellsberg and his team's genius, because the minute the New York Times got 3 days of publication out. We got 3 of the 10 or 12 days we were going to do printed before the government actually stopped us. And then immediately the Washington Post picked it up and the government stopped them. And then immediately it went to the Boston Globe. And from there, the St. Louis Post-Dispatch, and on and on. So what was going on was that once we had broken the dam, once we had demonstrated that we were prepared to take the risk, whatever it was, political, personal, judicial, at the New York Times, and other papers picked it up. I mean, it was a liberating, not only moment, but it was a liberating trend. And the fact that you had so many publishers of other papers who were willing to go ahead and print the Pentagon Papers after we had been shut down at the Times is a mark of the freedom of the press in America. It was a watershed time. It was a watershed decision. It was a watershed action by the Times.
Wonderful. And I think that I want to go back a little bit to now the Nixon administration's response. Now, John Dean has already said that initially his response was, this is good for us, the disclosure of the Pentagon Papers. But then things changed, and Henry Kissinger and the conversation between Nixon and Henry Kissinger seems to have been a turning point. So I wanted to ask John Dean that given that the paper's focus was more on previous administrations, and some have said that this, the Nixon administration's reaction was an overreaction. Could you share a bit about what was going on in the Nixon administration and the reaction of members of the administration to the Pentagon Papers, and their response, including efforts to kind of stop the publication, as well as to target Daniel Ellsberg. And so we need a kind of a little bit of a glimpse behind the scenes.
First of all, I should put myself in the proper perspective of where I was. As White House counsel, I had a great title for particularly somebody 31 years of age. What happened is when I got the title, and all the grunt work of the office. John Ehrlichman kept the job, and he had been my predecessor, and that continued really throughout Nixon's presidency. So I was not intimately involved in any of the decisions, was called occasionally for legal research and things of that nature, but certainly not on the front line or in the decision making of any of this. So my knowledge comes secondhand or even more. What happened is, and this has of course been written about by people who were in the room, Bob Haldeman, the chief of staff, that what Henry Kissinger told Nixon is that I can't effectively deal with North Vietnam in my secret negotiations in Paris, and your planned trip to China won't happen if we can't keep our secrets. And this is what got Nixon's attention. This is when he really overreacts, and they start down the road of prior restraint, deciding to go to court, deciding to try to stop publication, frustrated by the fact, as Hedrick mentions, as soon as they would succeed, as they did with the New York Times, with Judge Gerfine, who it was his first day on the bench, apparently, as I recall, and this was his first case, but he was familiar with classified information, so it was somewhat surprising that he decided to be the first federal judge to ever prior restrain a major publication. That was appealed quickly, and as we know, it was ultimately overturned by the Supreme Court. Interestingly, at the Supreme Court, I did pick up the disgruntled feeling of the Solicitor General, who didn't want to take the case for the government, who did not believe they should be taking the position they are or were. This was Dean Griswold, the former dean of Harvard Law School, who had been Lyndon Johnson's Solicitor General and stayed over and taken on the post for Nixon as well. As a result, people who were lower down in the Department of Justice were much involved in the Supreme Court case. And there were some issues as to the effectiveness of the briefing and how well, and most people were not even familiar with what was in the papers. This happened at the Court of Appeals level. It happened at the Supreme Court level, where we were told that the justices themselves went down and looked at the papers so they could better understand actually what they were. And this would affect their decision, of course, that this should not be a case of prior restraint. As Hedrick said also, these really were not highly classified documents that justified the classifications they had received. Anyway, let me go to my first personal involvement in this, and it comes in July, and it's the first sort of feedback I see of Nixon's reaction. I was unaware, as I am now, that Nixon, after the release, within weeks, is pounding on his desk and ordering a break-in at the Brookings Institute because he believes they have either a portion of the Pentagon Papers or other classified documents in their vault, and he wants someone to go in and get those papers out and, in essence, break in. Well, I learned about this from a former New York City detective by the name of Jack Caulfield, who had been assigned to my staff. He'd worked in the counsel's office for Ehrlichman, was on his way to the Treasury Department to take a job, but he came in wide-eyed. The president and his senior advisors are all in San Clemente, which was the norm in the summer. In June and July, they would go out there. And Caulfield tells me, he said, "John, you've got to help me. I've got a problem. I just came from Chuck Colson's office, and he wants me to break in the Brookings Institute and firebomb the place." And when the fire department is responding, before they get there, he wants me to send a team of burglars in to get in the vault and get some papers the president wants. I said, Jack, what are you talking about? Just don't do anything. He told me a little bit more of the story. I got on the first courier flight to San Clemente, out to California, and was determined to sit down with Ehrlichman and tell him that this was just absolute insanity. I also pulled down a copy of the DC Code, and at that time, if there was a death as a result of arson, it was a capital offense. So I laid my best case on Ehrlichman and told him, I said, this is just traceable directly to the White House. It's insane on any basis. And finally, he picks up the phone, calls Colson, and says to Chuck, young Counsel Dean is out here. Chuck does not think the Brookings plan's a very good one. Call it off. And looks at me, said, anything else, Counselor? I said, no, that'll do it. And I flew back to Washington. I would learn later, as a result of that trip, I would be precluded from knowing anything about the Plumbers operation. So I wouldn't find out about the Plumbers and what they were doing and their surreptitious entry into Dan Ellsberg's psychiatrist's office until after the Watergate break-ins, when on the morning of June 19th, I had a call from Jeb Magruder, the number 2 man at the re-election committee, who said, John, I need somebody to talk to Gordon Liddy, who's responsible for that arrest over at the Watergate. And I said, well, why aren't you talking to him? He said, well, I can't. I said, what do you mean you can't? He said, well, we had an incident at the elevator a couple weeks ago. I was going to play tennis, and Gordon owed me a memo. He was the general counsel of the finance committee, and I needed some information, legal information about how we were proceeding. And I, in a very nice gesture, put my arm on his shoulder at the elevator, and I said, Gordon, I really need that memo. Would you get it to me? And he said that Gordon brushed my arm off and looked at me, John. He said, it looked like he was going to kill me right there. But what he said is, Jeb, if you ever touch me again, I'll pull your arm out of your body and beat you to death with it. And I said, well, I understand why you're having trouble talking to him. I will talk to him. This is on the morning of June 19th. I call Liddy, tell him to come over to meet me, and I walk down. I decided this isn't the guy I want in the EOB office. So I walk down 17th Street, and he confesses that he and his men were responsible for the Watergate break-in and the arrest there. He said, John, he said, there's one thing you need to know. He said, there's a problem here that runs back to the White House. And I said, tell me what the problem is. He said, well, last September, I did a national security operation for Ehrlichman, and it was to break in Daniel Ellsberg's psychiatrist's office. The men I used in that operation, I used at the Watergate, and they're now in the DC jail. We've got to figure out how to get them out. I said, I don't think they'll talk, but I think there's national security issues here. Well, I said, Gordon, I will take that back to my superiors, which I would do. On the way back up the street, he memorably stopped me and said, I realize I've caused some very serious problems. And if you want to take me out, you just tell me which corner to be on and what time to be there, and you can do so. I said, Gordon, I don't think that's necessary yet. It probably should have been done, actually, in hindsight. But anyway, I go back and tell Ehrlichman what Liddy has told me, and he's clearly not happy that I know this information. It's also come out in the years since that Ehrlichman, in writing, had authorized the break-in at Daniel Ellsberg's psychiatrist's office. So he's got some real problems. In tracking the tapes over the years, it's very interesting that Ehrlichman never shares this, certainly in any conversation in the White House or in the recording device, nor any indication he'd shared it with Richard Nixon. But yet he knows right away. And the dynamics of the break-in in Daniel Ellsberg's office really change what happened after the arrest at the Watergate. It implicates the White House directly. And Haldeman has obviously been told about this. He does not open up to Nixon and say, Ehrlichman authorized a break-in with the same guys. He just refers to other problems on the tape. and he doesn't fess up. Nixon doesn't learn until I start dealing with him about 8 months after the arrest at the Watergate. I'll have 37 conversations with Nixon, and in about the fourth or fifth conversation, I realize he doesn't even seem to grasp why everybody at the White House is concerned about what happened during Watergate. And it's because these same guys who were used by Ehrlichman in this bungled California break-in operation. So to make a long story short, it is the Ellsberg break-in that is the reason that the White House becomes involved in the cover-up of the Watergate. I was convinced within 24 hours of the arrest that John Mitchell was going to come forward and say, listen, this happened on my watch. I don't know the full details, and so on and so forth. And he would resign and deal with it accordingly. And because he had told Haldeman to keep the White House out of it. It's also clear that Liddy, after confessing to me on the 19th, confesses to Mitchell through two of his aides the next day. And I see a dynamic change or dramatic change in Mitchell's behavior. When I thought he was going to clearly come forward, suddenly he is really pissed. He had no idea that Ehrlichman had sent these two clowns, Gordon Liddy and Howard Hunt, over to the re-election committee, where they got him in all kinds of trouble because they're nuts, they're lunatics, no judgment at all. And he didn't know what he had, that they had been ushered out of the White House by Ehrlichman because they were dangerous, and they'd been given a sinecure to keep them quiet. And somebody thought they would, but nobody had warned anybody about their nature. So, excuse me, this is one of the reasons I'm also convinced I ended up getting as deeply involved, because Ehrlichman trusted me, Mitchell trusted me, and after it came out what had happened, they could barely talk to each other. Ehrlichman was convinced that Mitchell had let them get away with this and not watched them, and Mitchell was convinced that Ehrlichman had stuck him with these clowns and not told him. So it really strained their relationship. It had already been a difficult relationship, but it became almost they couldn't talk or deal with each other in the same room. They would talk to each other by often turning to me and saying something to me like the other one wasn't even in the room. So I can't tell you how different Watergate would have been had Dan not leaked the Pentagon Papers. They probably would have been a break-in at the Watergate, sure. There probably would have been one somewhere else they'd have caused, because that's the sort of path they were on. But it may not have been as bad as it was because of the way it did actually unfold.
Okay. That is an incredible story. And that gets to one of the questions: would there have been a Watergate and a break-in without Daniel Ellsberg and the publication of the Pentagon Papers, which leads, as you kind of said, during the summer of 1971 to the formation of the Plumbers, this special investigative unit that G. Gordon Liddy and E. Howard Hunt were part of, and the targeting of Ellsberg that leads to this break-in of Daniel Ellsberg's psychiatrist's office, Dr. Lewis Fielding. It also leads Howard Hunt to produce a memo trying to smear Daniel Ellsberg's lawyer, Leonard Boudin, in the press, referring to him as the devil's advocate. And he sends that memo to John Ehrlichman. So this is all happening, the break-in to Dr. Fielding's office, as well as this attempt to also go after the lawyer, Leonard Boudin, in September 1971. And so the formation of the Plumbers and the break-in, you're saying that there might have been a break-in to the Democratic National Committee headquarters or elsewhere, but really it was that the Ellsberg disclosure and the formation of the Plumbers is essential, correct?
I think that what would have happened as a result of the Ellsberg leak, the so-called Plumbers Unit was created. And this was created, and there are tapes of Nixon talking to Ehrlichman and Bud Krogh about what he wants, how he wants it handled, and what have you. It is Krogh who later tells me that you're not involved in this because of your blocking the Brookings undertaking, which he thought was quite remarkable. I just can't understand whether there's anything remarkable about it at all. Just called sanity. But anyway, I did talk to David Young during that period, and he explained to me, actually, David, after they bungled the break-in into Dan Ellsberg's psychiatrist's office, they really disbanded the unit. And there are Supreme Court nominations that come up, and I'm in charge of going around to vet Supreme Court nominees. And Ehrlichman, who never trusts me because he thinks I'm Mitchell's guy, sends David Young, who has been the co-director of the Plumbers Unit, with me. And in the course of conversation, David doesn't tell me anything about what he's doing other than the fact where the name of the unit came from. And he said, I went home for Thanksgiving and my grandmother asked me, David, what are you doing? He said, well, grandmother, I'm trying to track down leaks for the president. He said, oh, David, you're a plumber at the White House. Well, he said, I took that back and told the others. And the next thing, somebody had drawn a sign and we put it on the door and called our little secret unit the Plumbers Unit. So that's where the name came from. It was David Young's grandmother who perceptively labeled it. But anyway, I knew little about their activity until long after the fact. And you're right, it would not have been created but for the fact that the president was just hell-bent on using and abusing the processes to try to nail Dan Ellsberg. Yesterday, on working on something else, I did a book called The Nixon Defense, as you mentioned, it's a book I would have never done had I known what I was getting into, where I took 4.5 years to transcribe all of Nixon's conversations. But I was looking for something else yesterday on the origins of the creation of the Senate Watergate Committee and Nixon's reaction. And they're debating it on the Hill on February 7th of 1973. And during that same conversation where they're talking about the Senate Watergate Committee, Ehrlichman is also telling the president that he doesn't think Dan Ellsberg is going to be prosecuted successfully in Los Angeles in the criminal case they've got. And it goes on at some length about how he thinks that they'll fail at the trial and the various moves and counter moves they've made. So any historian looking at that, this is not a public transcript, but they can dig it out. It's February 7th of 1973. Interesting information about the Ellsberg case in that conversation.
Well, thank you very much, because that's also a good segue into talking about Ellsberg's trial. So what we have is that we have an indictment by late December 1971 of Ellsberg for theft, conspiracy, and espionage, as well as Anthony Russo, who had assisted Daniel Ellsberg. You also have the lawyers Leonard Boudin, along with Leonard Weinglass and Charles Nesson, marshaling a defense. Fast forward, and you have to June 1972, the Watergate break-in. 2 days later, we have the Supreme Court, which declares that the warrantless wiretaps that the Nixon administration had been using, and which we've been talking a lot about people who've been wiretapped, were unconstitutional. This argument that we could use warrantless wiretaps in the name of national security violated the Fourth Amendment. So we have the break-in. We also have this important Supreme Court decision addressing Nixon administration's use of warrantless wiretaps as unconstitutional. And then we have the beginning of the Ellsberg-Russo trial in the summer of 1972, which actually ends up being delayed, and then there's declared a mistrial, that first one, because of a wiretap issue. And then by early 1973, what you have is a convergence of the retrial of Daniel Ellsberg and Russo, as well as the Watergate burglar trial. So the Watergate break-in trial is happening at the same time as the Ellsberg and Russo trial. And then we begin to see also more of an intersection as we get more into Watergate and the information that is coming from that trial and from information from those who are convicted and pled guilty coming into the Ellsberg-Russo trial. So I want to start talking about in kind of 1973, the Ellsberg trial and the testimony in that trial regarding the Pentagon Papers and the classification of them as being top secret, and some of Boudin's arguments, which include that the public has the right to know, the public owns the Pentagon Papers, that Ellsberg lacked a specific intent to harm the United States or to aid a foreign enemy, and that these papers do not relate to the national defense, which is under the Espionage Act. I'm going to bring in Morton Halperin to talk a little bit about his testimony as an expert witness in the Ellsberg-Russo trial now.
So I was an expert witness on both the content of the Pentagon Papers and the process by which they were produced. So I testified somewhat along the lines of what I talked about earlier on this panel, how the papers came to be written. And I also was the person who classified them. So I testified about the classification of the Pentagon Papers. And the interesting thing, which I pointed out, is that every page of the Pentagon Papers was classified top secret sensitive. And that included pages which were simply reproduction of articles from the New York Times. And the reason it was that we considered the project top secret sensitive, and therefore anything which revealed the existence of the project, we considered top secret sensitive. And the reason we considered it top secret sensitive is, first of all, McNamara had told us he wanted the project treated top secret sensitive. He didn't want people to know about it unless they were actually engaged in it. And we believed that if Lyndon Johnson or Walt Rostow, the national security advisor, found out that a bunch of people in the Pentagon, who they believed correctly, were trying to figure out how to get us out of Vietnam and would do anything that we thought was appropriate to get us out of Vietnam, were running a study, that they would terminate it. So we actually were ready every day for a termination. We had a plan to secrete the finished papers away from the White House in the hopes that they would not be destroyed. So that every page was classified without any judgment being made about the content of any particular page. And so there was no judgment that if you took a particular page or even a particular volume, as there were only some of the volumes that were part of the indictment, there was no judgment made that those documents were in fact top secret. And they were not the most sensitive documents. In fact, I've often said the word that appears most often in government conversations before the words top secret is only, as in that's only top secret, meaning it's not very seriously classified. If it's seriously classified, it has additional code word classifications, including classifications whose very existence is secret. Moreover, they ended in 1968. That was several years before. Almost everything that's classified secret loses its potency, loses its potential for harm very soon after it is released. So I was confident from the beginning that there was nothing in the Pentagon Papers which could reveal things that would harm national security. But I also got to testify on what was in the papers that was important for the public to know. We were surprised, I think, that the judge let me testify on that subject. And so I picked a few examples, starting with, and ones have been mentioned already or alluded to. The first one, for me, the most dramatic in some ways, because it was the one I was least familiar with, was President Truman. Truman had argued that the United States needed to aid the French to go back into Indochina, because otherwise the communists would take over Indochina, and that would be a threat to national security. Actually, what the Pentagon Papers show, that Truman was told that Ho Chi Minh was a nationalist, not primarily a communist, that he was not under the thumb of the Russians or the Chinese, that he would not make Indochina or Vietnam a satellite of the Chinese or of the Russians, and that the Vietnamese people supported him, and that therefore it would be extraordinarily difficult for the French to reassert colonial control over Indochina. But he was also told by the European Bureau of the State Department that if France was not helped to go back into Indochina, that the communists would be elected to take over the government of France. If France would become a communist country, it would therefore not join the NATO alliance, and Europe could not be defended. And so Truman's decision to go into Indochina, as the documents, this volume of Pentagon Papers makes clear, was a theory about communism in France and the theory of the NATO alliance, nothing about Indochina or the Ho Chi Minh's role in the international communist movement. And then later you had, when the United States first introduced combat troops into Vietnam, it did so, it said, at the urgent urging of the South Vietnamese government, it said that the situation would collapse unless U.S. combat troops were entered into the combat. What the Pentagon Papers volume on that showed, that the government of South Vietnam was very strongly opposed to the introduction of American combat troops, thought it would destroy their credibility. And we had to tell them, as we did, that unless they agreed to the troops coming in, not only agreed, but allow us to say publicly, if they had asked for it, that we would cut off all military aid to the South Vietnamese government, which they believed was essential to maintain their security. And then there was also clear evidence on the Gulf of Tonkin episode that our ships were there as part of a covert intelligence operation, and that's why the North Vietnamese attacked them, and that the second attack on the second day almost certainly never took place. So those are just three examples, but they're the ones I highlighted in my testimony as to why it was important for the American public to have access to the Pentagon Papers.
And should Ellsberg and Russo been charged under the Espionage Act?
Well, I practice as a lawyer, but without a license, so I'm not really the right person to answer that question. My view is that the Constitution does not permit the government to use the Espionage Act, which has to do with people aiding and abetting foreign powers, to criminalize the action of either government official giving the information to the press or the press publishing the information. I think the government can enact, as it has done, some very narrowly tailored statutes relating to the identity of covert agents, relating to communications intelligence, which you can make it a crime in very narrow circumstances to make public. But a broad statute that says anything relating to the national defense can be made public, can be made classified, and people can be punished, and the press can be punished for publishing it, is, in my view, a policy mistake, but also a violation of the First Amendment.
And you testified on behalf of the defense in this trial.
Yes, I not only testified on behalf of the defense, I worked for the defense. I was out there for most of the trial, and my main job was to recruit former government officials to testify that things in the Pentagon Papers that looked very secret were actually not secret, and that revealing them would not damage the national security. So we had a number of very prominent former government officials who testified at my urging at the trial.
And we also see that there's another element that enters the trial. So what most people will remember from the Ellsberg Russo trial is that it ended a mistrial and was dismissed. But that didn't just happen. What happened was that there was a lot of information that's been revealed after the Watergate break-in investigation, information that's being disclosed from John Dean, information coming from the Senate confirmation hearing of FBI acting director L. Patrick Gray. There's a lot of investigation information that somehow makes it into is now related to the Ellsberg trial. And one of the revelations is the break-in to Dr. Fielding's office. So that's one that enters the Ellsberg trial. We also have the revelation that Morton Halperin has been wiretapped, and that there is a recording of his conversation with Ellsberg, and that is also revealed to the judge. And
Right.
the last element here is that there is a public revelation and disclosure of a communication from John Ehrlichman to the trial judge that is in offering him that maybe there is a government position, a
Director of the FBI.
assignment in the government. And so these elements kind of come together. They come into the trial. We have now an intersection of Watergate investigation and investigations in the Nixon administration, and the Plumbers now entering the Ellsberg trial, and more evidence of corruption by the Nixon administration, which leads, marshaled by Leonard Boudin, leads to this trial and dismissal of the charges, where the judge finds the totality of the circumstances, quote, offend a sense of justice. But Morton Halperin's wiretap becomes kind of part of this.
I think it was not only part of it. I think it was the only one that made any difference.
Yeah.
Because we would do what we came to call laughingly the weekly motion for dismissal on the grounds of grave governmental misconduct, and we would present, that the judge was offered the job of the FBI director, or that there was a break-in at Daniel Ellsberg's psychiatrist office. And at the end of each one of these arguments, the judge would say, Mr. Boudin, show me a case which says the remedy for government misconduct is the dismissal of the case against the defendant. And of course, there was no such case. What was different about the report of the wiretap, which my understanding is came about because John Dean informed the Justice Department that Ellsberg had been overheard on the wiretap on my phone. And of course, the government had filed an affidavit swearing that neither Ellsberg and I had been overheard. And so the government the Justice Department was informed. It made the correct decision that it had to notify the judge. The judge was notified. He was also told that the files had been stolen from the FBI and the Justice Department, and that nobody knew where they were, which turned out to be wrong, because the next day, Ehrlichman revealed that he had them in his safe, that they had taken them out of the Justice Department, but Ehrlichman had them. And I think it's an open question whether the judge would have dismissed the case if he knew the wiretap files existed. Because if they existed, they could have been examined to determine whether they tainted the defense in any case. And in fact, they did not. I have just right behind me the transcripts of all the wiretaps, including the ones with Ellsberg and me, and Ellsberg talking to other people from my house. And none of them bear in any way on the indictment of Ellsberg for the Pentagon Papers release. So I think if Byrne had been told, we made a mistake, we did wiretap these people, but here are the files and they can be examined to show there was no tainting, that he might not have dismissed the lawsuit.
All right. Okay, so that we have now more information about that wiretap and the dismissal of the case. So now within a week, we have the public hearings of the Senate Watergate Committee and testimony by John Dean about the Watergate and cover-up and Nixon's knowledge and approval. And then we're on the road to the articles of impeachment and Nixon's resignation in a little over a year. So now this is more of a familiar story with the revelation of the tipping system, the appointment of the special prosecutor Archibald Cox, the subpoena of the tapes, the Saturday Night Massacre, and in 1974, the House Judiciary Committee begins its investigation into impeaching Nixon with public hearings in May and approval of articles of impeachment. We now turn to Elizabeth Holtzman, finally, to talk more about her role on as a member of the House Judiciary Committee during this time. Can you tell us a little bit about your experience and what you're wrestling with the obstruction of justice and abuse of power in your investigation of the Nixon administration?
That's a big question, but first of all, let me just start out because I want to make this point. The House Judiciary Committee really did very little of an investigation. It took most of the materials and evidence that it acquired, both from the grand jury that was turned over to us as a result of a court order by Judge Sirica, and also materials that had been accumulated and obtained by the Senate Watergate Committee and some other committees in Congress. So the idea that we had done our own homework was not exactly accurate. With regard to the House Judiciary Committee, I'll just mention that Jimmy Breslin, who was a well-known reporter in New York and with a national reputation, wrote a book called How the Good Guys Won. Didn't mention good gals, but how the good guys finally won. And his theory was, I'll just put this out, a little bit of more speculation. This Morton Halperin speculated about Judge Burns, that if I hadn't defeated Emanuel Seller, who was the then chair of the House Judiciary Committee, that there might not have been a successful impeachment of Richard Nixon. Now, of course, I had no idea that there was going to be an impeachment of Richard Nixon. That when I ran for office in June of 1972, it's a very significant month for me too, and because it was the farthest thing from anyone's mind. I won the primary against Emanuel Seller. I ran actually on an anti-war platform. I was elected on an anti-war platform. And in November, when I won, the primary in Brooklyn was a decisive election. So in November, when we finished the general election, of course, that was pretty nominal, and I was reelected. I was elected landslide. I went down to Washington to try to get a committee assignment. And I didn't want to be on the House Judiciary Committee because my predecessor had been on it for 50 years. I said, maybe it's strike out on a new path, maybe deal with some different issues, and also maybe he has some friends on the committee. I didn't know what kind of reception he'd get. So I went to Washington that November and December and lobbied not to be on the House Judiciary Committee. Well, my first legislative defeat, I'm put on the House Judiciary Committee against my will. Now, I just have to say, and this is the proof, that if anyone in the House of Representatives had any idea that there'd be an impeachment of Richard Nixon, I would never have been put on the House Judiciary Committee. And so that's the biggest proof of that fact, because I had no political clout. I myself had run against the Democratic machine. I had no supporters in the House of Representatives. So it was clear when I took office and was sworn in that impeachment was the farthest thing from anyone's mind, except maybe in the White House. That's a different story. They knew what they had done. Nixon knew what he had done. But in the House of Representatives, nobody really had put the whole story together. So it was that part was a big surprise. But obviously, as the facts came out slowly, it was a steady drip. By July, the first resolution of impeachment, July 1973, was introduced by Father Drinan, and it had nothing to do with Ellsberg, and it had nothing to do with the break-in and Dr. Fielding's office. It had nothing to do with Watergate. It had to do with the bombing, the revelation about the secret bombing of Cambodia. And that received almost no support, and it went nowhere. But that was the first public discussion about it. I can recall, certainly, official discussion about impeachment. As the summer went on, John Dean's testimony, the work of the Senate Watergate Committee, the facts seemed more and more compelling. But the House of Representatives was not moving on impeachment. It was a granite opposition to any impeachment. There was no talk about it from the Speaker. There was no talk about it from the Majority Leader. There was no talk about it from Peter Rodino. It wasn't until the Saturday Night Massacre, which took place in October of 1973, when Archibald Cox, the special prosecutor, was trying to obtain certain tapes from the White House. Nixon had recorded his conversations in the White House. John Dean had testified, I told the president there was a cancer on the presidency. I told him that the burglars were demanding payoffs. They were blackmailing us. And Nixon said, I know where you can find the money for that. And Nixon said, of course, this is a lie. Well, there were tape recordings. The tape recordings would show whether John Dean was telling the truth or whether the president was telling the truth. That was very easy to understand. Cox gets fired for trying to get those tapes, which will tell whether the president's telling the truth or not. American people understood that. They understood, wait a minute, these tapes would vindicate the president. So he's firing somebody who's going to get those tapes. There was a huge public outcry, huge, enormous. It was pre-internet days, but there was a huge outcry. Telegrams, letters, phone calls flooded the members of Congress's offices. And at that point, impeachment started to be taken seriously. In fact, at that point, really, the impeachment effort began. Peter Rodino, who's the chair of the committee from New Jersey, started an effort to find Counsel, finally latching on to, and was a very wise, strategically wise decision, to find a Republican counsel that set the tone for the operation of the committee, that the chair was going to be reaching out in a very serious way to Republicans as well as Democrats. And that's really what started the process. But I want to say just a second here that if you go back, there are 2 points to be made. One is that the Vietnam War is really the kind of linchpin of all of this. Whether it's the Ellsberg Trial, the Pentagon Papers, the break-in, the Watergate break-in. So that's a theme that's running through this. And the second thing is happenstance. That this might not have happened necessarily. Because, first of all, having Peter Rodino as chair, if I hadn't run and I hadn't won, maybe it would have been a different outcome. Secondly, the Senate had decided that there had to be a special prosecutor. But the Senate really didn't have the power to do that, except that all of a sudden, there was no attorney general. You had Mitchell had been the attorney general, then he obviously left to become campaign chair, and then you had Kleindienst, and Kleindienst had to leave because of questions of possible criminality. So there was a vacancy in the attorney general spot. And at that point, the Senate wanted to know what was going on and wanted a special prosecutor. So the Senate had leverage it wouldn't have had otherwise. The Senate said, okay, you want to have an attorney general? That's fine. But you're not going to get an attorney general unless you get us a special prosecutor. And without that leverage, we wouldn't have had Archibald Cox. The way the Justice Department was conducting the investigation was, in my opinion, you could say diplomatically haphazard. Certainly it wasn't really aggressive. Let's put it that way at the best. You could say other things about it at its worst. But anyway, you may never have gotten the tapes. You may never have gotten the kind of investigation that would have produced the results it did. So without those kinds of happenstances, who knows whether there would have been an impeachment inquiry or the substance of it or the nature of it. But by the time we got the counsel in place, the committee, did a very thorough job. We had to go through all the mounds of evidence. You had the Pentagon Papers, Hedrick Smith, to go through. We had to go through all the mounds of testimony that had been compiled by the grand jury and by the Senate Watergate Committee. There was a lot of work to do to comprehend the massive amount of information. But we did. And I think in the end, because the process was very fair and substantially bipartisan, the American people strongly supported it. And Nixon was removed from, the committee vote was bipartisan vote on 3 articles of impeachment to remove Nixon from office. and then he resigned in the face of the disclosure of the Saturday night of the smoking gun tape, which showed that he actually instructed the CIA, his staff, to get the CIA to stop the FBI's investigation into Watergate, and that was really the end of it. But there was huge public support for the impeachment result by the committee, and I believe that Nixon resigned in the face of certain, it would have been a certain impeachment, a removal from office and conviction in the Senate. And it's a process that worked, but it wouldn't necessarily have worked if all the pieces hadn't fallen into place.
And part of these articles of impeachment included obstruction of justice, which is in part of the kind of the Watergate and aftermath and cover-up, but also abuse of power in office. And that was a little bit that was broader than Watergate. That it also included the targeting of Daniel Ellsberg, correct?
Yes, there were three articles of impeachment. The first one really involved the obstruction of justice in the Watergate break-in. The second article of impeachment had to deal with Nixon's abuses of power. Some of it was overlap because some of the obstruction of justice that took place in connection with the Watergate break-in involved abuses of power. And that had that second article of impeachment had the most support from Republicans, and it included the wiretaps, the illegal wiretaps, the variety of surveillance that was conducted by Richard Nixon for personal and political purposes. Then, of course, it also had to do with the break-in into Daniel Ellsberg's psychiatrist office. It had to do with the offer of the directorship of the FBI that was listed as part of the grounds. And then, of course, you had all the other abuses of power that we saw, including the obstruction of justice in the Watergate break-in and the enemies list, again, related to the Vietnam War. Nixon decided that he was going to, Morton Halperin, you were, I guess, one of the enemies of the country. So you were on that list. People who opposed Nixon's policies were told that, they weren't told, but the IRS was told, you've got to audit these people. I, in fact, was audited by New York State and the federal government for just being on the House Judiciary Committee. I was audited, my staff was audited, my campaign was audited. I've never been audited before or since, but all together in connection with my being on the House Judiciary Committee. So yes, abuse of power was a very serious and important article. The third article had to do with Nixon's obstruction of the impeachment effort, refusing to provide information to us and respond to subpoenas.
We have actually now 5 minutes left. 5 minutes, but I think that we can still do another lightning round of final thoughts. 1 minute each of kind of the significance and why we should learn more about Ellsberg and his legacy in the Pentagon Papers and the publication, its importance, or also contemporary relevancy to whistleblowing, and what we can learn from the Pentagon Papers and Ellsberg and Watergate and abuse of power that we're seeing in recent administrations. So worth studying, contemporary relevance. John Dean, what do you think?
I'd like to just thank the University of Massachusetts Amherst and this panel for focusing on the importance of archival material. You've got a bunch of archival people on your panel.
Walking archives.
So, exactly. So it just shows how history does have continuing relevant. And as I was listening to this, I kept thinking of how this has played out in the last few years during the Trump administration, and different times, different outcomes. But again, we haven't heard the end of that story either.
Great shout out to archives. Excellent. So James Goodale, what do you think?
Well, I think that it's worth focusing on the importance of the decision in the Pentagon Papers case. And I don't think it's really, as such, gotten the attention it deserves. Clear and present danger is something we've all grown up with. We rejected that test. I didn't have a chance to tell you about such rejection, because clear and present danger isn't as good as immediate danger. And so we took that test and turned it around and spent a lot of time working on it and made the danger in question to the nation or its people. That's very hard test to meet. So one of the important legacies of the Pentagon Papers case, and we should say Daniel Ellsberg too, is that First Amendment law was strengthened and advanced, and some of the controversy that grew up over Holmes' use and not the greatest use of the clear and present danger by some people's estimate, or a debate that started almost 100 years ago. That's all been cleared up, as long as the test remains, as I've said, of the Pentagon Papers case. And as I said earlier, I don't think that test is going to change. I think the Pentagon Papers case is going to be like all the famous cases that we've heard about when we studied American history.
Hedrick Smith.
I think what we're talking about here is the guardrails of the republic. We're talking about the diffusion and the responsibility of people in different walks of life in different institutions. The media being aggressive, questioning, honest, straight, fair, but probing. The courts playing a decisive role. Honest officials within administrations, John Dean, Brad Raffensperger, if you will. People, regardless of party politics, coming forward and doing what their oath of office and their commitment to the country says. We've just had the institutions of this country run roughshod once again in the last 4 years. Involvement of foreign powers, president using foreign policy, defense power to influence other countries to help him in domestic elections. A slew of things. And we're reminded, I think, by this story, how important it is for us to repair the guardrails of our republic, to have active institutions, to have a dispersal of power, and actually to see our democracy survive. It's on trial today. And I think this is a particularly relevant, important historical recollection. But when you listen to the variety of stories that the five of us have told from different perspectives, every single one of these people and every single one of these institutions was important. And that's true today, particularly today. So thank you for doing this. It's very timely.
Thank you. Morton Halperin.
Yeah, I want to echo what my fellow panelists have said. We owe a great debt to the people involved in Watergate and in the impeachment, including John Dean, including the New York Times, its lawyers and its reporters, including the House Judiciary Committee, all of whom stepped forward above and beyond the call of duty to honor their commitment to the Constitution. And we survived, and we've survived in other cases as well. What I think we haven't done is to strengthen the laws in a way that will help us be more likely to succeed in the future. Freedom of Information Act needs to be strengthened to make it possible for courts to order the release of classified information. The whistleblower statute needs to be strengthened to provide for a public interest defense, an intention not to harm but to help the nation as a defense for whistleblowing. And there are other statutes that need to be strengthened. But I think for now we can celebrate what was done at that time and the role that all of these institutions played in that process.
And last word, Elizabeth Holtzman.
Well, what the Pentagon Papers legacy is one, you need courageous people in government, because we know, and the framers of the Constitution understood, that there would always be people who would seek to be tyrants, who would abuse power, who would threaten our democracy. We had 2 break-ins under Nixon. We had the biggest break-in of all in the Congress of the United States, instigated by the last president we had, Donald Trump. We are not free from those kinds of people, and we will never be free from the threats to our democracy. But we need to have people of principle in every single niche of power that we have. And the minute we start making our courts totally political, taking people of principle out of Congress, influence of money and other things, we threaten our democracy. People who are in decision-making positions need to be people of principle and character. And that's what's going to save us, as well as people of courage in government.
Thank you all. Thank you to all the panelists for a wonderful session. And thank you to UMass Amherst and to GroundTruth Project and all the organizers of this terrific conference. It's been a pleasure. Have a wonderful rest of your day.
Thank you.
Thank you.
That's all.